Thank you, Mr. Chairman. Good afternoon. Mr. Chairman, distinguished members of the Tribunal, my name is János Jákó, and alongside my co-counsel, Mr. Tamás Enzsol, we represent Respondent in present proceedings. Concerning this issue, the matter of litigation costs, Respondent has three main submissions. First, it will submit that for the breach of the arbitration agreement, the unilateral model law shall be applied. Second, that should the CISG be found applicable to present matter, legal costs are in principle not recoverable under Article 74 of the CISG, and if they are found recoverable, then the requirements found in Article 77 CISG are not met. Concerning my first submission, Respondent wishes to submit that the arbitration agreement, as by the agreement of the parties, is guided by the Danubian arbitration law. As the Danubian law is the governing law, and there are no provisions in the Danubian arbitration law to base damages on, it must be seen that damages are not reclaimable for these actions. Also, Respondent would like to highlight the fact that claimant heavily contributed to the breach of contract, also by ignoring the interests of Respondent in person during the visit of Mrs. Buharit, and also in its letter on the 2nd of December that can be found on page 14 of the record, when, despite the fact that Respondent explained to claimant its situation, it continually and repeatedly demanded full performance. Also, claimant had a legal right to turn to the National Court in Mediterranean for the interim injunction, but this heavily contributed to the fact that Respondent in the end decided to breach the contract between the parties. Second, that if the CISG is found applicable, legal costs are excluded from the scope of reclaiming damages, as this would first of all result in a violation of the principle of equality, one of the main principles of the CISG, as it can be read in both Article 45 and 61 CISG, as only a successful claimant would be able to reclaim these costs. Therefore, this naturally would result in a violation of Respondent's rights in present case. Also, as it can be seen from the Zapata case, national procedural law cannot be circumvented, and also now the international principle of res judicata, judged matter, now protects this issue, as the order for costs was not granted for claimant. Therefore, this must be seen. Also, in the CISG Advisory Council Opinion number 6, it can be clearly stated, and this is also supported by Professors Schlechtrim and Schwenzer in their commentary, that litigation expenses are excluded from the scope of the CISG. Should they be found foreseeable despite those submitted by Respondent, the interim injunction was not a foreseeable measure on claimant's part, as national court proceedings are atypical proceedings in the wine industry, and also there was no immediate risk of sale. Therefore, the interim injunction was brought in vain, while the declaration of non-liability on Respondent's part was preceded by a letter of Respondent in which it tried to clarify the situation, where it notified claimant that the arbitration clause was, in its opinion, unworkable, but it would accept arbitration should claimant reply so. But claimant completely ignored Respondent, therefore Respondent had no choice to turn to national court. In conclusion, Respondent wishes to submit that the unilateral model law has to be applied for the breach of the arbitration agreement, that legal costs are in principle not recoverable under Article 74 CISG should the CISG be found applicable, and if they are, then claimant does not meet the requirements of recoverability under Article 77 CISG. In conclusion, Respondent would humbly like to ask this tribunal to rule against claimant in all matters and not granting document production, the disgorgement of profits, or awarding claimant the costs suffered by litigation. Thank you.